All right. So moving on to the next Rekieta thing, and this is actually something here, Chad, I told you about. The reason why I didn't do this on its own, because it doesn't really warrant a, oh my gosh, breaking news. Because, once again, we expected this. We have information on KAYLA's suppression motion. If you guys remember, KAYLA is Nick's wife. She was also charged with the possession of drugs, having the firearm in the home while drugs were present, and then she was also charged with an additional offense, which is a little different than Nick's, and she was charged with child neglect or endangerment as a different violation of the Minnesota statutes. But we do have the order on the Omnibus, so that's something we're going to tackle here real quick. So the order following the Omnibus hearing. So on October 28th, there was an Omnibus hearing. KAYLA appeared with her attorney, and the state of Minnesota also showed up. KAYLA's got the second-degree possession as a felony. The possession of the weapons by an ineligible person, and neglect or child endangerment. And so they talk about at the hearing, they received Exhibit 1, which is the application for the search warrant, the receipt and inventory and return. And they said following a briefing schedule, meaning both sides had the chance to submit briefs, they had the court, and from here, the court took the matter under advisement December 9th. So, guys, remember, it's been about 21 days, about 3 weeks roughly. And that you're throwing in the holidays, Christmas and New Year's. And remember, I mentioned this before, guys, courts kind of grind to a halt as you get close to Christmas. Really in December, once you clear Thanksgiving, court slows down. You don't usually have like trials after Thanksgiving. Like nobody really wants to do a whole lot. And then you get to Christmas, and then you're in between Christmas and New Year's. Not a lot really happens, chat. Not a lot really happens in court. But they say, based upon the exhibit's filings or proceedings, the court makes the following motions and determinations. And we're going to skip all that real quick because we're going to get to the memorandum of law. And they go through here. And ultimately, just like Nick, KAYLA is asserting the search warrant was effective because it lacked probable cause. And the information had no indicia of reliability, was conclusory and based on speculation. And Detective Pomplin, guys, remember, is the head detective that was leading the investigation here. He lacked training and experience to offer an opinion. Now, before we get too far, we should probably actually talk about all this. So on May 24th, and for those of you guys who don't remember, the Kansas County Sheriff's Office submitted an application for a search warrant, and they were going to raid Nick and KAYLA's house and the property owned by Nick and KAYLA. The property subject to the warrant was known by Detective Pomplin to be the residence of Nick and KAYLA, and KAYLA's the defendant in the situation. The search warrant was for controlled substances prohibited by law, drug paraphernalia for the use of controlled substances, and items that show the controlled substances are not legal drug paraphernalia. They got their search warrant on May 22nd. Now, primarily, what are they looking for? And coke accessories. If you guys remember, Nick had the infamous coke stream where he shows up all powdered up, all dreary, and then he's all jazzed up and fired up, and then he slogs off again. And that was that's really the last true stream Nick has done on YouTube, was back on May 21st. So the police the next day get everything going. And we go back to the beginning. And May 16th, the sheriff's office received a report of neglect and drug use involving Nick and KAYLA. And that was done by their pastor of their church, who said, other people have reported it to me, and we have concerns for the kids' safety and well-being. So after that, the detective started reviewing Nick's social media videos, and Detective Pomplin noticed Nick's appearance changing from January to May, which it really did. Nick's changes appeared and are noted as common with drug users, and yeah, they kind of are. And right after Nick crashed and burned that night, he also reviewed Aaron Imholt from Steel Toe Morning Show, reviewed his media videos, and Imholt hosts his own show. And from watching Imholt's videos, it's apparent that Nick and Aaron had a friendship and have since had a falling out. Aaron stated that he's recently experimented with cocaine and Molly. And Aaron on the 22nd uploaded a video where he spoke about Nick and insinuated he was using drugs. Well, a little more than insinuating, but yes. Yes, he was doing a lot. He referenced Nick's video by the 21st, and from there, the sheriffs then looked around and they found Nick's video because they initially searched for it. His video was removed, and later they found it. Now they found Cog's upload, and remember the watermark nonsense. Well, on that video, you can see a white powdery substance is on his nose. This is where they talk about Nick's video being 4 hours, 4 minutes, and 4 seconds in length. At 2 hours and 46 minutes in, Nick leaves the video to use the restroom. Upon returning at 2 hours and 50 minutes and 40 seconds, Nick appears with a white powdery substance on his nose. His demeanor is excited, and at one point he closes one eye to be able to read speech, rambles, and then slurs his speech. Remember, guys, the judge had to watch the entire thing because Nick, it was arguing about all this. The May video was recorded in the basement of his house. And Pomplin is previously a drug recognition evaluator. Remember, guys, I said DREs are bullshit. But remember, Nick was so intoxicated and high, any one of us could readily tell something was going on. So it didn't require his training experience. Almost anybody could see Nick was completely on there. So anyways, they believed that Nick was using a central nervous system stimulant and a depressant. Alcohol and cocaine. Coke stimulant and alcohol the depressant. So on May 23rd, the police raided the home. They found a black vial with a white substance inside. They tested positive for cocaine. A snort tube near the nightstand, positive for cocaine. They found just 22 casings on the floor. It's for art. They found an AR-15 with several magazines loaded under the bed, which that itself isn't a crime, but when you're doing drugs, the state has determined it to be a crime, and whether you like it or not, it's a crime, so don't do it. A glass container and with metal filter and grinder in the bedroom, positive for coke. A 45 caliber bullet in the closet. A bag with cards and a dollar bill in the safe in the bedroom, positive for cocaine. A corner cut baggie with white powder in the master bedroom safe, positive for cocaine. 3 small baggies in the safe, positive for cocaine. Green tablets in the safe that tested positive for ketamine. You're like, ooh. We're doing some special K here, chat. A digital scale in the bedroom, testing positive for cocaine. A metal pan with white powder, positive for coke. Snort tubes and metal cutters in the safe, testing positive for coke. A $100 bill with cocaine residue on it. A bindle bag, testing positive for coke. Like everything, a coke scooper, baggies with a funnel, unknown brown substances, which field tested negative. And those apparently didn't come back with anything from what we could tell, chat. A 1911 handgun, a 380 handgun, a 12-gauge shotgun, and then ultimately 26.67 grams of coke with all the packing. So that's what they found. And basically the court's saying, Kayla, this is bullshit. We don't agree with you. They talk about here, the Fourth Amendment requires the right of the people to be free from unreasonable search and seizures, and there must be a finding of probable cause in order to issue a warrant under the Fourth Amendment and the Minnesota Constitutions. You're like, okay, cool. So in most instances before searching a particular residence, and remember, a search warrant has to be particular, has to be particularity. Where are you going to go and what are you looking for? Because if you don't, that's a general warrant. We're going to this house and we're looking for X. We believe X is there based on, and that's where you develop probable cause. So when you review probable cause, you determine if there's a common sense basis for the search. And all you have to do is set forth evidence, competent evidence sufficient to lead a reasonably prudent person to believe there's a basis for the search. And it's done under totality of the circumstances test. So that's all you have to do. And here you can't review each component in isolation. You have to analyze the warrant as a whole. So if you're going to go through all that, we've already covered this multiple times, chat. They say in the present case, the search warrant application states law enforcement began their investigation after receiving an allegation of child maltreatment. concerning Nick and Kayla's kids. Minnesota statutes and regulations emphasize the protection of the identity of reporters and informants in the context of child maltreatment investigations. As such, the search warrant does not include the identity of those individuals. Yes, but we do know from the police report itself that it was Pastor Mellon from their church who did it, and hat tip to the pastor for trying to take care of the kids. Once the maltreatment began, the investigation began, Deputy Pomplin reviewed the defendant's husband's social media, meaning Nick's. And from there, he noticed, he had a wide variety of experiences and hundreds of hours of training. He mentioned this in the affidavit. While reviewing the videos, Pomplin observed Nick with a white powder on his nose and behaviors consistent with being under the influence. The video was recorded in Nick's home. And cops can rely on training experience to draw inferences in affidavits, but mere suspicion does not equal probable cause. Well, they had a lot more than mere suspicions. He used his drug recognition evaluator and experience as a cop to support the information here. But to be fair, guys, remember, we all saw it too. Like, there's no way you would sit there and say, oh, he's normal. He was clearly drunk the entire stream, and then he got, completely blitzed on cocaine because he comes out of that break taking off like a rocket ship. And so they say, based on the experience as a drug recognition evaluator, Pomplin believed Nick was exhibiting signs of polysubstance abuse. The observations made by Pomplin of the behaviors are detailed within the affidavit and further corroborate the concerns about Nick and Kayla using drugs. As a whole, the affidavit presents specific facts which demonstrate support for a search warrant seeking controlled substances in the residence. Yeah, once again, this is nothing we already didn't know or hadn't talked about. Now, here, once again, the court points out the court does acknowledge using social media video as support for a warrant is unusual. Well, yeah, it's kind of a rare thing, but it's going to become more and more apparent. And caution must be used to ensure that an altered video, or like one with watermarks in it, parodies, etc., are not used as support for a warrant. In this case, there is no indication Deputy Pomplin did not watch Nick's original stream, nor is there any evidence the video is altered or a parody or otherwise inaccurate, and that's correct. Nick spent how long screaming about the watermark, but he does nothing to show why the video itself is inaccurate. Considering the totality of the circumstances, the warrant demonstrates a fair probability that contraband or evidence of a crime would be found in the Rekieta residence. Accordingly, there is sufficient information in the affidavit to establish probable cause to support the search warrant. Defendant's motions to suppress and dismiss the charges are denied. And yes, chat, we go up here to the top. So what do we see in the order? The defendant's motion to suppress all evidence is denied. The motion to dismiss the charges is denied. All others issues not argued with particularity or otherwise specifically identified to the court as a contested issue at the omnibus hearing, whether included in the written notice or not, are denied, having been waived by the defendant. The court shall order a settlement conference, and the memorandum of the court is incorporated. So Nick and Kayla, they have his and hers denials. So it matches. They have couples things. It's like, oh, they got matching for the holidays. That's good. That's good. Good for them. Good for them, chat. They got denied. Now, what does this mean? They're toast. There's nothing you can fucking do. It's over, chat. It's over. Yes, the freedom dies when Nick is denied. Yes. Yes, America, chat. America died a little bit today. So, America denied a little bit today. Sadly, it denied. It's all over, chat. America has fallen. America has fallen.
I'd be open.